a very clear position assertion. In short, the first factor identified by the pretrial chamber is, in essence, simply a recitation of the fact that Jordan decided not to comply with the court's request. As such, it constitutes a decision by a pretrial chamber to refer the findings of non-compliance based simply on the fact of non-compliance. This appeals chamber, however, has stated that a decision of non-compliance sending alone does not result in an automatic referral. In Prosecution versus Kenyatta, the appeals chamber said that, based on the wording of Article 87 of the Rome Statute, an automatic referral to the external actors is not required as a matter of law. Furthermore, this appeals chamber was not persuaded that such automatic referral would be beneficial as a matter of policy as contended by the prosecutor. The second factor advanced by the pretrial chamber as warranting the referral, which may be found in paragraph 54 of its 2017 decision, was that the pretrial chamber had previously expressed an unequivocal position to an entirely different country, which is South Africa, that it was obligated to arrest President al-Bashir. This reliance by the pretrial chamber on such a factor is manifestly an error of law, as the prosecution itself concedes. An indiscriminate comparison of two states' parties would be inappropriate. A state party's referral must be decided primarily with reference to its own facts, not to the situation of a different state party. This is precisely what the pretrial chamber did not do in its reliance on the second factor. The prosecution seeks to argue that the second factor somehow concerns a general principle and statement of law that all states parties were obliged to arrest Omar al-Bashir, rather than a reference to the pretrial chamber's decision on non-compliance with respect to a completely different state party, which is South Africa. That assertion is misleading and rather clearly rebutted by the actual text of paragraph 54 of the decision under appeal, which says nothing about a general principle or about a statement of law or about all state parties. Instead, paragraph 54 expressly refers to the pretrial chamber's unequivocal position expressed with respect to South Africa. As one of its questions posed in advance of the hearing, the appeals chamber asked, in what circumstances, if any, would it be desirable for the court to refer a state to the Assembly of States Parties or the Security Council in respect of non-compliance pursuant to Article 87, paragraph 7 of the statute, when it is no longer immediately possible to obtain the specific cooperation requested. The League does not wish to suggest hypothetical circumstances in response to this question, but we do wish to point to the appeals chamber's own standard, which was expressed in the Kenyatta case. There, the appeals chamber said that a referral should only be sought when the chamber concludes that it is the most effective way of obtaining cooperation in concrete circumstances at hand. No such conclusion was reached by pretrial chamber in the present case. Mr. President, members of the appeals chamber, due to the pretrial chamber's manifest errors, It is the League's contention that the third ground of appeal should be granted. The Arab League attaches the highest importance to this ground since it could be very damaging to the operation of the League if a member state were brought before the Security Council and the Assembly of the States Parties simply because it was fulfilling its duties as host state of the Arab League Summit in accordance with our agreements. I conclude, Mr. President, by reiterating the League's basic position. In our view, Jordan was obliged under the Pact of the League of Arab States and under the 1953 Convention to respect the immunity of President al-Bashir during his visit to Jordan in March 2017 to attend the Arab League Summit. Furthermore, Sudan was a sending state within the meaning of Article 98, Paragraph 2 of the Rome Statute, such that the court could not proceed with the request of Jordan for the arrest and surrender of President al-Bashir in the absence of a waiver from Sudan. Neither Article 27 of the Rome Statute nor Security Council Resolution 1593 affected these obligations of Jordan with respect to the Arab League. Had Jordan arrested the head of state of a member state of the Arab League during its summit, it would have severely undermined the proper functioning of the Arab League and jeopardized its ability to pursue its objective, which include the maintenance of peace and security within the Arab region and at the world at large. The League once again appreciates your willingness to allow us to address both groups B and C this morning. And before concluding, there was a question posed by you, Mr. President, about the effect of Chapter 7. And I heard a lot about Chapter 7 yesterday, and having served in the United Nations for about 35 years as ambassador and as diplomat and as Under-Secretary General in the United Nations, there are many ways to read the implications of Chapter 7 in Security Council resolutions. Many of the peacekeeping operations, for instance, are established by resolutions of the Security Council under Chapter 7. But nonetheless, it requires an agreement between the United Nations and the state concerned, where the United Nations find it sometimes difficult to reach, because the state concerned can ask that specific countries do not participate in this force, can ask that this force be limited in presence into certain locations, can ask that certain leadership should be accorded and certain linkage between the political and the security structures of the peacekeeping operations should be established. And the member state can ask that this peacekeeping operation, even though it is established under Chapter 7, leave the country. And that happened in Burundi, when Burundi asked that BNOP leave the country. And the United Nations struggled legally with whether it's the obligation that the establishment of a peacekeeping operation under Chapter 7 would allow the UN to go to impose itself on Burundi. And the United Nations realized that it cannot. And that is for one. And the other one is related also to the situation in Darfur, UNAMID itself. When Sudan requested that UNAMID would leave, Sudan did that, if I recall correctly, in 2008 or 2009. Maybe my memory is not serving me right. And the UN had to enter into a very extensive negotiations with Sudan, even though this is a Chapter 7 operation. And this resulted in lowering the composition of the mission down to the half and into a major changes in the political structure and the relation between the political and the military and the police components of this particular mission. So saying that Chapter 7 gives absolute authority to the Security Council on the ground is not 100% true. There is still sovereignty, there is still negotiations, there is still the role of the state concerned. Thank you.
Thank you very much, Ambassador. There was one question I had posed earlier when you made reference to my questioning. I thought that's the one you were coming to, but it wasn't. I'd asked the question before in the manner of when we have summits of regional groups, regardless of or without prejudice to the legal question, would it be something to consider? Some ambassadors, some professors have spoken to it. Some of them very reluctantly, like Professor Kress, did not want to speak to it, but he did. It is something to be said that in those circumstances, regardless of the correct legal answer, that perhaps diplomatic sensitivities and that sort of thing may make it a wise policy to not seek arrest in those sorts of meetings. It's something that the Arab League will urge. It's a matter of policy, not of law.
As a matter of policy, the Arab League is looking into what are going to be the implications of the implementation of this kind of decision. And the implications are going to be severe because, as I explained in my presentation before, the summit meets only once a year. And it meets to review the results of about 19 organs of the Arab League that are meeting year-round, including 2 ministerial meetings for ministers of foreign affairs and many other ministerial meetings that are related to others. So all these decisions are pouring in this particular meeting. So implementation of this kind of decisions will have severe implications on the ability of the Arab League to implement its regional decisions and its regional dimensions. And that is where, in the essence, that is the Arab League is committed to the implementation of Article 14 of the 1953 Convention, which I cited in my submission last time.
And one more question for you about the interpretation of Security Council resolutions under Chapter 7. You've spoken to that it can be, different animals depending on circumstances, and you're saying it may be simplistic to take only one view of it. Do you recall how it all played out in the context of Kosovo?
Well, I'm not an expert on Kosovo, so
sorry. I'll leave you.
Apologies.
Thank you
Mr.
very
President.
much. Thank you very much. Now we will take submissions now from the legal scholars. We will begin with Mr. Kress.
Your Honours, the questions in Group B essentially concern the legal effects of Security Council Resolution 1593 on the alleged immunity ratione personae of President Bashir. In my statement today, I wish to make 6 points in that respect. First, the customary law avenue, which, as I have shown, is open to the court, is logically prior to the Security Council avenue with which I shall deal today. Second, it is also open to the court to proceed through the Security Council avenue to reach the result that the court was entitled to request Jordan to arrest and surrender President Bashir without the need to first obtain a waiver of immunity by Sudan. Third, in case the court does not wish to deal with the customary law avenue for reasons of judicial economy, it must not negate it by implication. Fourth, the Security Council avenue has appeared in two variants in the jurisprudence of this court. These are not fundamentally different. Instead, their legal essence is the same. Under both variants, paragraph 2 of the Security Council resolution has displaced Sudan's possible immunity rights ratione personae for the purposes of the present proceedings. Fifth, the more straightforward and therefore preferable variant of the Security Council avenue is to interpret paragraph 2 of Security Council Resolution 1593 as implying the direct displacement of the possible immunity ratione personae of President Bashir. Sixth, the same result may be reached as a fallback option through the second variant of the Security Council avenue, that is, the application of Article 27.2 of the ICC statute to Sudan, again by virtue of the paragraph 2 of Security Council Resolution 1593. Let me begin by explaining my first 3 points. Since 2008, I have been maintaining that there are two legal avenues to reach the result that the court may request a state party to arrest and surrender President Bashir without the need to first obtain a waiver of immunity by Sudan. For convenience sake, I have been calling the first legal avenue the customary law avenue. I have set out this avenue in some detail in my written observations, in my interventions, and in my interventions during this hearing so far. I have been calling the second legal avenue the Security Council avenue. Here, it is the legal effect of Security Council Resolution 1593 that allows the court to request a state party to arrest and surrender President Bashir without the need first to obtain a waiver of immunity by Sudan. As a matter of legal logic, the customary law avenue is prior. This is for the following reason. As the immunity ratione personae is subject to a customary international criminal court exception, including the cooperation level, there was no need for a Security Council resolution to displace such immunity. The logical priority of the customary law avenue over the Security Council avenue does not mean, however, that the chamber must proceed through the customary law avenue. In fact, as the prosecution has correctly pointed out, the chamber can also choose, for reasons of judicial economy, to proceed through the Security Council avenue. You know well, Your Honors, that this is not what I suggest the chamber should do. But if the chamber wished to do so nonetheless, it should make one thing clear, that it is hereby not reaching a negative decision on the customary law avenue by a necessary implication. The chamber should then say, for example, that any possible immunity ratione personae of President Bashir has been displaced for the purposes of the present proceedings by virtue of Security Resolution 1593. Let me now turn to the Security Council avenue more in detail and to my other 3 points which relate to it. In the jurisprudence of Pretrial Chamber 2, as well as in international legal scholarship, the Security Council avenue has appeared in 2 variants. Let me first explain why those variants
Mr. Kress,
differ only by way of a nuance.
can you, 1 second. I'm looking at the,
So, excuse me, sir.
thank you. This question has been hanging in the air. Prosecutor has been arguing it, and now all you say, the resolution lies, the answer to the question lies in dealing with Customer International, but so it doesn't have to be done, but to say any possible immunity left has been displaced. Is that the ideal way to do it, or is there not, in this case, a necessary need to verify the existence or not of immunity under customary international law, and then say, regardless of the existence, it has been displaced, if that is the correct answer, that Security Council has displaced that? Can we proceed as if we don't want to know whether or not there is customary international law? Is that a safe way to answer this question? If it is, does it avoid a possibility of another instance of a similar question, perhaps not in identical circumstances, arising in future, and we're all here again in a few years' time?
Thank you, Mr. President, for this extremely important question. I will address it fully, if you allow me, in my final observations, but I will be brief here, not in order to lose too much time, but just a few observations. If you follow Jordan's argument that the Security Council avenue has not displaced the alleged immunity, then I think you must approach the question of customary international law, because it is premised on that argument. And this, as you know, is a question that has not yet fully been reasoned by the appeals chamber so far. Pre-trial chamber 1, in the Chad and Malawi decision, has taken a unanimous stance on customary international law, which is fully in line with my position. Pre-trial chamber 2 has then, as we all know, deviated from that, but with respect.
But this is the appeals chamber. We are bound by neither
That's
pronouncements
true. Yeah.
of either pre-trial chamber.
And all the more I would encourage the appeals chamber in those circumstances to pronounce its own view, precisely because pre-trial chamber 2 has simply asserted that there is no customary international law, but has not reasoned it. But on the...
So there is, basically you were saying, in the jurisprudence of the court, there are two views from the pre-trial chamber. One pre-trial chamber says something about customary international law, it is there. Another pre-trial chamber says, no, it is answered on a different basis, and say there is a need to resolve that.
This is precisely to the point, I believe, Mr. President. Therefore, I would think, in case you follow Jordan, that the Security Council avenue is of no avail, I think you have to deal with customary international law. What I was saying, in addition, if you, however, take the view which I find correct, agreeing with the prosecution and others, and I shall explain that the Security Council avenue is also open. In that case, I believe, even though the customary law avenue is logically prior, you can, for reasons of judicial economy, leave the question of custom open and still reach the correct result. In my concluding observations, I will argue that this would be a missed opportunity. Let me now come back to the Security Council avenue in more detail, and I need to speed up a little bit to catch up time. In the jurisprudence of the pre-trial chamber 2, as well as in international legal scholarship, it has appeared in two variants. Let me first explain why those variants differ only by way of a nuance. Under the first variant used in the DRC decision, the Security Council has, by virtue of the second paragraph of Resolution 1593, displaced any possible immunity right of Sudan ratione personae for the purposes of these proceedings. In other words, the imposition on Sudan of a duty fully to cooperate with the court has displaced any possible immunity ratione personae of Sudan for the purposes of these proceedings. Jordan could therefore not have acted inconsistently with such immunity right if it had executed the court's request. Under the second variant used in the South Africa and in the appealed decision, Resolution 1593 has got precisely the same effect. But here, this effect results from the fact that Article 27.2 of the ICC statute has become applicable to Sudan. I agree with Jordan that pretrial chamber 2 could have been more than a little clearer regarding the question which of the first two paragraphs of Resolution 1593 has made Article 27.2 applicable. Jordan's reading of the South Africa decision that this applicability is the result of a combined effect of both paragraphs is a plausible one. My suggestion is that reliance on the first paragraph is not essential. The second paragraph of the resolution is key here as well. Jordan has placed emphasis on the difference between the two variants, even to the point that only the second is on appeal. I respectfully submit that this is a significant overstatement. To the contrary, the core of the two variants is identical. Under both variants, paragraph 2 of the Security Council has displaced Sudan's possible immunity rights, ratione personae, for the purposes of the present proceedings. Under variant 1, the imposition on Sudan of the duty fully to cooperate has displaced Sudan's possible immunity without further. Under variant 2, the duty fully to cooperate has ultimately done the same, but through an intermediary step. This step consists of having triggered the applicability of Article 27 to Sudan. There is thus no more than a nuance between the two variants. And it is therefore unsurprising that two main arguments that Jordan has directed against the Security Council avenue concern both variants. Let me take them up briefly to express my agreement with the prosecution that none of those arguments is convincing. The first argument is that the displacement of immunity by the Security Council requires an explicit provision to that effect. I understand this to mean that the relevant resolutions mentions the very words immunities, ratione personae. With all due respect, this proposition is untenable. There is no legal requirement to that effect, and the Security Council's own practice clearly speaks against that proposition. Just consider that it is consistent practice of the Security Council to authorize the use of force without using the words use of force. To save time, I shall leave it to my distinguished colleague and friend, Mr. Robinson, to say more on this. His amicus curiae brief contains an entire list of powerful arguments in that respect, and I fully endorse them. The second argument is that the ordinary means of interpretation of a Security Council resolution would not justify the conclusion that paragraph 2 has displaced a possible immunity ratione personae of President Bashir. This argument, too, lacks persuasive force. Instead of rehearsing them, I fully endorse the entire list of powerful considerations which were set out by the prosecution yesterday with regard to the ordinary meaning, the context, the background, and the purpose, and which are also contained in the amicus curiae brief of the Darrell Robinson group. I only wish to explicitly comment on one counter argument because this argument has not only left me unconvinced, it has also saddened me. Reference has been made to the continued inaction of the Security Council after the repeated briefings provided by the prosecutor of this court about Sudan's obvious failure fully to cooperate. It has been suggested that this could count as subsequent practice against the displacement of Sudan's possible immunity. And this, although it is clear that the continued Security Council inaction is not based on a unanimous legal view of its members, but essentially on political considerations. As a humble citizen of the world, Mr. President, if I may take up your words, I take the liberty to express my sadness that the Security Council has first mandated this court to take action in the situation of Sudan in order then to let the same court down when the Council's support was needed. Let me now take up the one single argument which I believe to have detected, which is specifically directed against the first variant of the Security Council avenue. That is, the direct displacement of possible immunities through paragraph 2 of the resolution. Jordan argues that the Security Council cannot invent new cooperation obligations in addition to Part 9. But by displacing Sudan's possible immunity, the Security Council has not invented any new cooperation obligation. It has done nothing more than to make it impossible for Sudan to pose an obstacle to its full cooperation. I therefore respectfully submit that the most straightforward and therefore preferable variant of the Security Council avenue is to hold that the Security Council, by virtue of paragraph 2 of Resolution 1593, has displaced Sudan's possible immunity right ratione personae. But this is not to say that the second variant of the Security Council avenue is flawed. It is only a little less straightforward because it takes a short detour via Article 27. In case the Chamber disagrees with my view that paragraph 2 of the resolution should be interpreted as implying the direct displacement of President Bashir's possible immunity, the detour via Article 27 offers a perfectly sound fallback option. Let me briefly, to conclude, explain that proposition. The words "cooperate fully," as contained in paragraph 2 of the Security Council resolution, also appear in Article 86 of the ICC statute. Article 86 states the general cooperation obligation of states parties. This is a very clear indication that paragraph 2 of the Security Council resolution seeks to place Sudan in the same legal position as state parties as regards cooperation. Not transforming it into a state party, that's not the point, but to place Sudan in the same legal position as state parties as regards cooperation. But is Article 27.2 relevant for cooperation? Jordan argues that it is not. I respectfully beg to differ. Instead, I agree with the view of the pretrial chamber and that of the prosecution that Article 27.2 is very relevant to the cooperation level. Article 27.2 states that immunities ratione personae, among other things, shall not bar the court from, I quote, exercising its jurisdiction over a person. The exercise of the court's jurisdiction over a person includes the issuance of a cooperation request for arrest and surrender with respect to this person. This interpretation, based on the ordinary meaning of the words used in Article 27.2, is powerfully supported by the need to ensure that Article 27.2 has a practical effect. What would be the consequence if Article 27.2 were of no relevance to the power of this court to issue a request for arrest and surrender? The consequence would be as follows. The same state party, may I finish these two paragraphs? Or
it was a 5-minute call. You've got 5 more minutes.
Thank you, Mr. President, but I will not exhaust.
Much more time than I'm sure
Yes,
you
no, I will
expected.
not exhaust them. It was just such a relief. Thank you so much. The consequence, now I can really slow down. The consequence would be as follows. The same state party that has waived its possible immunity ratione personae in its direct relationship with the court by virtue of Article 27.2 could rely on that very same immunity when being in a position of a third state within the context of Article 98.1. This would not only slightly, but drastically reduce the practical effect of Article 27. Here we should not be naive and ignore all historical experience of international criminal justice. This experience tells us the following. It is only too realistic to expect that a state party whose sitting head of state is subject to an ICC arrest warrant will be as reluctant to fulfill its arrest and surrender obligation under the statute as Sudan is reluctant, to put it mildly, to fulfill its arrest and surrender obligation under Security Council Resolution 1593. Thus, Article 27.2 must be of relevance also for the cooperation level in order a substantial practical effect is maintained. This provision can therefore be applied to Sudan in view of the fact that its duty under paragraph 2 of the Security Council resolution fully to cooperate has placed that state, once again, in the same legal situation as a state party as regards cooperation. This concludes the explanation of my 6 points. I thank your honors.
Thank you very much, Mr. Kress. We will go next to the next speaker, Ms. Latanzi.
Merci, monsieur. Oh, pardon. Merci, monsieur le président, de me donner la parole sur ce que je considère le nœud central de l'affaire al-Bashir. Au centre du chapitre 7 de la Charte, le Conseil de sécurité a bien le pouvoir de faire exception à la règle coutumière ou à une règle conventionnelle en matière d'immunité du chef d'État qui, naturellement, ne touche pas au but, au principe des Nations Unies selon l'article 24.2 que vous évoquez aussi dans une de vos questions. C'est justement ce que le Conseil de sécurité a fait par implication nécessaire dans la résolution 1593. En particulier le paragraphe 1, le paragraphe 2, en rendant applicable en conformité avec le chapeau de l'article 13 et la disposition spécifique 13b du statut, toutes les règles du statut concernant l'exercice par la Cour de sa juridiction de cognition et d'exécution dans la situation des crimes de Darfour, y compris naturellement l'article 27 par rapport aux officiers soudanais bénéficiant d'une immunité selon le droit interne ou le droit international, y compris naturellement si c'est le cas, si c'est pertinent, de l'article 98 1 et 2. Je ne comprends pas comment on puisse tout le temps se référer à l'article 98, 1 et 2, après avoir affirmé qu'on n'applique pas l'article 27. Ils sont quand même liés. D'ailleurs, étant donné que le Conseil de sécurité s'est référé dans le préambule de la résolution au rapport de la commission Cassese, qui, comme vous, Monsieur le Président, l'avez dit hier dans votre introduction, évoquait les responsabilités des officiers du gouvernement du Soudan, le Conseil avait bien clair à l'esprit que certains officiers de haut rang puissent être destinataires d'un acte d'accusation par la Cour. Donc, on ne peut pas opposer à cette conséquence nécessaire de l'application conjointe de l'article 13, chapeau 13 bis, et de la résolution 1593, que pour rendre applicable l'article 27, le Conseil de sécurité aurait dû s'exprimer expressément sur cela. À part le fait qu'alors il aurait dû faire toute la liste des règles du statut applicables en l'espèce. Mais si le Conseil avait explicitement évoqué l'exception aux immunités visées par l'article 27, cela aurait constitué une ingérence indue dans la compétence exclusive de la Cour de décider, même dans l'intérêt de la justice au titre de l'article 53.2, quel suspect de crime poursuivre dans la situation au Darfour. On ne peut donc même pas se surprendre du fait que le Conseil de sécurité n'ait jamais pris position sur la soi-disant dénonciation dans les rapports périodiques du procureur de la persistante non-coopération avec la Cour, d'un côté du Soudan et de l'autre des États destinataires de demandes d'arrêt remises de M. al-Bashir. Je note en plus à ce propos que l'intervention du Conseil de sécurité au cas de violation du statut, même dans le cas du renvoi d'une situation à la Cour par le Conseil de sécurité, est prévue selon une procédure bien précise qui donne la compétence aux chambres d'en décider de ce possible renvoi. Et donc, le Conseil de sécurité, par son silence sur les conséquences de la dite non-coopération, a correctement évité de toucher cette compétence. Pour la même raison, il ne s'est pas occupé d'un conflit éventuel entre les obligations des États en matière d'humanité selon le 98.1, tandis qu'il a pris en considération l'article 98.2. En décidant au paragraphe 6 de la résolution l'application de cet article au personnel et des contingents mis par les États à la disposition des Nations Unies. D'ailleurs, cette matière est strictement liée à la responsabilité principale du Conseil de sécurité en matière de maintien de la paix, et ce qui implique son pouvoir de ne pas laisser seulement dans les mains de la Cour de l'interprétation de l'article 98.2. D'ailleurs, il appliquait telle disposition en parfaite conformité avec sa signification littérale et selon ce qui apparaît des travaux préparatoires à propos de l'existence d'obligations externes au statut limitant la juridiction de la Cour par la prévision d'une juridiction nationale exclusive. Par rapport à une autre question posée par les juges, je prends l'opportunité de souligner fermement ici que le fait que le Conseil de sécurité se réfère au paragraphe 6 de la résolution 1593 à une exception spécifique à la juridiction de la Cour relative d'ailleurs à une matière, à une fonction que les Nations Unies expliquent, ne signifie pas du tout une reconnaissance de la possibilité d'autres exceptions. Il signifie plutôt le contraire. Autrement, on l'aurait énoncé explicitement. Pour conclure sur la question de l'applicabilité du statut en application des dispositions conjointes du statut et de la résolution, et aux États non partis mais impliqués dans la situation renvoyée, cette implication est une reipsa. Et une reipsa en application de deux actes internationaux adoptés dans le contexte de deux systèmes particuliers, différents, conventionnels, mais dans le contexte du même système, du même ordre international, et qui donc se combinent en parfaite harmonie, à condition qu'on les soumette naturellement à des critères d'interprétation coordonnée, contextuelle, selon les critères de la Convention de Vienne. Le Conseil de sécurité n'a donc aucune nécessité d'évoquer de manière explicite dans sa résolution l'effet normatif de la résolution par rapport au Soudan, ni en particulier l'applicabilité de l'article 27. Sur cet aspect, je me réfère à une question intéressante que vous avez posée aux représentants de la Jordanie à propos de la possibilité de distinguer entre obligations et valeurs contraignantes. Vous avez parfaitement raison. C'est là qu'il y a la nécessité de faire cette distinction. Une chose, ce sont les décisions obligatoires du Conseil de sécurité quand il décide. Autre chose, c'est l'effet coercitif de ces décisions quand il, en plus d'obliger, limite aussi la souveraineté des États. Donc, l'effet coercitif touche justement la souveraineté des États, ce que le Conseil, on peut même penser malheureusement, mais le Conseil peut faire sur la base de l'article 2, paragraphe 7, comme de la charte, comme naturellement, plus spécifiquement, des dispositions du chapitre 7. L'effet normatif de la résolution 1593 ne veut pas dire que l'État impliqué dans la situation déférée devient un État parti ou un quasi-parti ou analogue. Ce statut, je suis d'accord avec la Jordanie, n'existe pas dans le droit international. L'effet normatif signifie que l'État impliqué, tout en n'étant pas partie au statut, et les autres parties impliquées, comme dit la résolution de la situation, sont obligés à reconnaître la juridiction de la Cour par rapport à telle situation et à coopérer pleinement avec la Cour selon les dispositions du statut, afin de permettre l'exercice plein de la juridiction de la Cour. Donc, tant la juridiction cognitive que la juridiction d'exécution, et donc les mandats d'arrêt, de remise et la demande d'arrêt de remise. Maintenant, la question que vous posez de la différence entre l'approche différente que le Conseil de sécurité a eue par rapport à cette question de la coopération, en ce qui concerne les États partis d'un côté, le Soudan de l'autre côté, et les États membres des Nations Unies, mais non partis au statut. Le Soudan, je l'ai déjà dit, est obligé à la pleine coopération. Et par contre, le mot que le Conseil de sécurité utilise, urges, par rapport à la coopération sollicitée, je l'ai dit en anglais seulement parce que l'original c'est en anglais de la résolution, par rapport à la coopération sollicitée aux États non partis au statut autre que le Soudan, ne comporte pas l'obligation de ce dernier à une telle coopération. Mais il y a une doctrine autorisée à laquelle je n'ai pas bien approfondi cet aspect, mais je me sens assez proche. Selon cette doctrine autorisée, on peut bien retenir que la sollicitation vigoureuse à la coopération de ces États entraîne une autorisation à déroger afin de maintenir la paix et la sécurité internationale aux immunités auxquelles le Soudan aurait droit d'après le droit international envers ces États, c'est-à-dire une faculté de coopérer avec la Cour même. Si on accepte la théorie de l'effet d'autorisation de certaines résolutions du Conseil de sécurité, les conséquences juridiques différentes entre l'obligation de coopérer et la sollicitation à coopérer comporteraient que dans l'exercice de son pouvoir se poserait le problème du rapport entre l'article 27 et le 98.1 par rapport à la demande d'arrêt remise adressée à un État non parti du statut, outre que le Soudan. Elle demanderait donc, la Cour demanderait au Soudan de renoncer, et si le Soudan, à son immunité, ne renonce pas, la Cour pourrait quand même adresser au dit État une demande d'arrêt de remise de l'accusé, le sollicitant, comme le fait la résolution, à son exécution sur la base de l'effet d'autorisation. Toutefois, si cet État refusait une telle coopération, il ne commettrait naturellement pas une violation du statut, mais ce comportement pourrait être soumis à une évaluation différente de ce comportement sur la base des règles de la Charte des Nations Unies auxquelles vous faites référence dans 2 ou 3 questions que vous posez. L'effet d'autorisation pourrait aussi expliquer la raison pour laquelle des États non partis au statut de Rome aient cherché à éviter la présence d'Al-Bashir sur leur territoire. Et donc, cette approche différente à la question de la coopération est tout à fait cohérente avec le pouvoir discrétionnaire conféré au Conseil de sécurité par l'article 39, ou de décider ou de recommander des mesures pour les situations considérées par l'article. Il n'est donc pas du tout surprenant que le Conseil de sécurité ait choisi en l'espèce simplement de solliciter et pas d'obliger les autres membres des Nations Unies à la coopération avec la Cour. Pourriez-vous d'ailleurs imaginer que les États membres permanents du Conseil de sécurité et non partis au statut, comme les États-Unis, la Russie, la Chine, auraient fait passer une résolution qui les aurait obligés à coopérer? On sait bien que, malheureusement, ce n'est pas le cas. Maintenant, la question que vous posez de la résolution du Conseil de sécurité, pas obligatoire, par rapport à d'autres résolutions de cet organe ou à l'Assemblée générale. Naturellement, c'est seulement le Conseil de sécurité qui peut adopter des résolutions obligatoires et contraignantes et coercitives. Naturellement, ce n'est pas une question d'instrumentalisation. Je me réfère à une autre question que vous posez de la Cour par le Conseil. Je pense que la résolution établit une coordination harmonieuse entre ces pouvoirs et la juridiction de la Cour, comme ça a été aussi pour l'article 13b. On pourrait plutôt dire que la Cour se sert du Conseil de sécurité et le Conseil de sécurité se sert de la Cour, chacun dans le cadre de ses compétences. Je passe outre la question si la Cour, pour question d'économie de temps, est un brainchild au nom du Conseil de sécurité. Je pense que c'est surtout la réalisation d'une idée des États et surtout les like-minded qui ont combattu jusqu'à la fin pour cette Cour, pour son institution, qui est naturellement une institution tout à fait séparée des Nations Unies et on n'a pas besoin de rappeler comment elle a été adoptée sur la base d'une conférence diplomatique et d'un accord adopté. En ce qui concerne la demande d'arrestation et de remise par la Cour d'un accusé sur la base du renvoi, l'État, en exécutant cette demande, je pense que plutôt qu'agir par délégation de la Cour, qui n'a pas à sa disposition une police judiciaire, et donc, sur cet aspect, elle n'a rien à déléguer. Je pense que par cette demande, par l'exécution de cette demande, l'État fournit à la Cour, au sens du statut, seulement des moyens coercitifs nécessaires pour l'exécution de la demande d'arrestation et de remise dont la Cour n'est pas dotée, selon l'imagine que nous a donnée Cassese de cette relation entre la Cour et les États, entre les tribunaux internationaux et les États.
Il vous reste 5 minutes, professeur.
Dans cette demande d'arrestation et de remise, la Cour ne demande donc pas à l'État d'exercer sa juridiction, ni de cognition, ni d'exécution, sinon dans les limites très strictes dont l'article 59 du statut.
You have about 5 more minutes, just so you know.
L'article 59 est particulièrement illuminant à ce propos parce que ne donne pas du tout à la juridiction interne de s'occuper de l'immunité. Je passe outre, laisse à votre relecture cet article. Maintenant, il y a un groupe de questions que vous avez posées qui s'occupent de la relation avec les décisions du Conseil de sécurité, avec l'activité du Conseil de sécurité en matière de la paix, donc la nécessité que les États exécutent ces décisions. Et il y a des dispositions générales qui sont les mêmes que vous citez, qui effectivement se préoccupent beaucoup de l'exécution de ces décisions. les immunités et donc le Soudan, la Jordanie, qui n'ont pas respecté les décisions du Conseil de sécurité, se trouvent en une situation d'illégalité dans une matière très importante du droit international, la répression des crimes affreux. Les immunités internationales dont l'État est titulaire en tant que tel expriment certainement le principe par imparem non habet jurisdiction, mais je ne crois pas du tout que c'est le cas pour les immunités personnelles des agents d'État de haut niveau ou aussi de plus bas niveau, s'il y en a. C'est l'intérêt de relations sans entrave interétatiques et à l'intérieur d'organisations internationales n'a rien à faire avec la question de la souveraineté. C'est un intérêt mineur. Et donc, elles peuvent être dérogées au nom d'un intérêt supérieur. Et donc, toutes les normes citées par les juges dans leurs questions s'appliquent pour permettre le respect des décisions du Conseil de sécurité. Et l'État ne peut même pas opposer une obligation de droit coutumier. Et sur cela, je me permettrai aussi de suggérer une approche à la Chambre d'appel. Sur cet aspect, il faut se rappeler qu'il y a un principe général du droit qui, pour le droit international, est un principe fondamental, encore plus que pour le droit interne. Le principe lex specialis derogat generali. Et donc, avant de se poser le problème, s'il existe ou non une règle coutumière en la matière, en l'espèce, il faut se poser le problème s'il y a des règles spécifiques. Et je renvoie sur cela à un rapport très intéressant sur la fragmentation du système juridique international de la Commission du droit international, qui parle spécifiquement de ce principe ius specialis derogat generali. Et donc ici, on a des règles spécifiques qui sont les règles du statut. On a encore des règles spécifiques qui sont celles de la résolution 1593. Donc, ce sont les règles qui doivent aussi, sur la base de l'article 21.1 du statut, être avant tout prises en considération. C'est seulement sur la base de ces règles la Chambre d'appel ne réussit pas à résoudre la question qu'elle se posera la question des règles coutumières existantes en la matière.
Votre temps est terminé.
Naturellement, j'aurai beaucoup de choses encore à aborder. Est-ce que j'ai encore quelques minutes?
No, your time expired 2 minutes ago. Thank you very much, Professor. Did you hear?
Sorry. Thank you so much.
Thank you very much.
I end.
Thank you very much.
Thank you.
It is time for our morning break, but I note on the record that Mr. Newton has now joined us. Perhaps for general discussions...
sorry. I was not
It's okay.
following.
Perhaps one way to look at one of these questions amongst many that have been posed is, again, in light of the distinction that the ICTY appeals chamber drew between coercive effect and mandatory effect. Now, whether or not urge, when the Security Council urged all states to cooperate, whether that can translate into a mandatory effect for purposes of UN Charter, even beyond the question, even in that way, there remains another way to look at it. And if we looked at it from the perspective of responsibility of states for internationally wrongful act, could it be that a state that is urged by the Security Council under Chapter 7 to fully cooperate may, on the basis of that, transgress any immunity that is agreed to exist, but then plead a defense if there is litigation arise from that. So look, we were urged to do this thing, and we were fully cooperating according to that urge. So we are absolved from internationally responsible act. Let's leave it at that for now and come back in 30 minutes. Thank you very much.
All rise.